as to our panel, we focused on the constitutional liability. In a given sense, for us, it was an easy task, taking into account that here in the Central European Academy, we already had research. Here is the QR code, and of course, this is open access. Therefore, if you would like to check it, there are, for example, in the conclusion, there are tables via which you try to compare in an easy way the legislation of 8 countries. Therefore, not only the Visegrád countries, but other countries, regulation and practice were analyzed. Therefore, that was a basis for us. And therefore, my question was that we asked the colleagues to present, especially the developments since 2022. Okay, therefore, it's I think it was really good. Way, I think, for the authors. As to the research 2022, these areas were analyzed as to the constitutional regulation and the practice. The liability question was also part of this analysis, and similarly the duties and obligations of the given authors. However, to try the two, taking into account that there are links between or among these different topics, therefore it's not so easy to separate the different topics from each other. And there were some comprehensive questions as well in the project, and in the present one, we also ask these questions, the good practices that please help us to determine which are the good practices in your country. And of course, if you have the legal referenda proposals, we were really open to read it. As to the research in 2022, as to the good practice, you can see that no authors determined good practice in connection with the liability. It's an interesting message. And as to the legal referenda proposal, there was only one country from which there was a kind of demand that we should do something with this liability specific issue. Maybe it's connected to a voluntary-based principle. And what is the situation now with the present issue? If I'm correct, there were not great changes in the Slovakian regulation in practice. However, I was really glad that our professor colleague and the authors, they presented for us the legal referenda proposals. This kind of the legal referenda proposals, they were not in the previous project. One of them connected to the so-called favorable environment. It is regulated in the Slovakian constitution, and the idea is to give substantive content to the notion of the favorable environment. It was also another interesting issue connected to this law, to the who are which kind of persons can refer to this law, and as to the legal referenda proposals that we should, the Slovakian decision maker, lawmaker should broaden the scope, also involving legal persons. That was the proposal, and another important proposal that to specify more clearly what means the careful use of natural resources. It's also an important part of the protection of natural resources in the Slovakian constitution. But what does it mean, the careful use, especially? That was the question. As to Poland, it's the situation. It was really lucky because the author of the Polish chapter in the research of 2022 Bartosz Majchrzak, he was the person, and now he's the author of the article. And as to me, I think in the article there was more details about the constitutional practice, but the constitutional practice of the higher, the supreme administrative and administrative courts, because as to and the author drew our attention to the fact that not merely constitutional tribunal has the opportunity to interpret the constitutional regulation, but also the administrative court. And it was especially precious for me that classified and analyzed how the administrative court did it and does it. Therefore, I think it's especially an interesting part. And however, my colleague Professor Majchrzak already wrote in the book some ideas, but in my opinion, a little bit he modified his ideas. Not a problem, of course. And therefore, there were some new or partly new ideas in connection with this. They connected to the principle of sustainable development, broader material scope that environmental protection alone. That it means that the sustainable development principle should be applied not merely in connection with environmental affairs, but in other affairs as well. And there were also ideas in connection the right to health and how to use it, how to interpret it. Also in connection with the participation in environmental protection matters, right to public participation in environmental protection matters. I think it's a really interesting right. For example, in Hungary, there is not specific right in connection with this, but in Poland there is. And interpreting court establish a fundamental human rights to a clean, health, and sustainable environment, because at this moment in the Polish law there is not a kind of right to a healthy environment. Therefore, that is the question as well, whether they should introduce this specific rights, so you can this right, or they can solve the issues with the previously determined rights. As to Hungary, the situation is a little bit different as in comparison with the previous mentioned countries, because in Hungary that was a new flagship decision in 2025. It was in connection with our climate law. The climate law, it was adopted in 2020, and as to this decision, given parts of the law of the act adopted by the parliament was repealed by the Constitutional Court, referring to these articles: the protection of natural resources, right to health, right to healthy environment, and what is the situation here? It's as I noticed, this is a flagship judgment. Therefore, it has a complex modification direction. Not only one part was modified of the previous legislation. I tried to somehow summarize the change for you. First, I would like to present what was before the situation in the practice. Especially, I would like to draw your attention to the red words. The definition of natural resources in Hungary, definition of future generation, the role of the Constitutional Court issue, and the right to a healthy environment. I think they are the affected issues. What is the situation? First of all, with the role of the Constitutional Court, I have to emphasize that, taking into account that the Hungarian constitution is one of the newest constitution in our region, maybe it's not a surprise that it is full with the reference of sustainability, with sustainable development, with protection of the future generation interest, and so on and so on. Therefore, the text is very, I think, trendy and new, very green. And in addition to this, the Hungarian Constitutional Court is also very, very active. And and manage this right as a very strict right. Therefore, if I can use, it's very progressive, I think, the practice of the Constitutional Court. Another interesting issue that how the Constitutional Courts, they are typically court of law, therefore not the court of fact, But and of course, this is the general attitude and characteristic of the Hungarian Constitutional Court as well. But in connection with the environmental protection, the Hungarian Constitutional Court has a kind of court of fact attitude. They in front of the court they try to prove, for example, whether the previous level of protection was changed or not. There are opinions from different organizations. It's really interesting, I think, and maybe this attitude can be interesting maybe also to you if you would like to, for example, improve or this constitutional standards. This, I think, one way of this, to find a proper court in this way. I don't know whether is it the proper direction or not, but it's interesting. That is the whether in positive way or negative way. This is a question. And another issue that is the dynamic interpretation. I try to find the proper word dynamic. Dynamic, I didn't want to use the activism. But to tell you the truth, in my opinion, it was almost activism. But I didn't want to write it in this way. Therefore, dynamic interpretation, maybe it's because of the methods and reasoning used by the Constitutional Court, I think it's very extra. Definition of natural resources. There are some interesting words in the Constitutional Court practice. First of all, in the text of Constitution, there are some examples. What does it mean, natural resources? What I think was really interesting, this public trust doctrine applied by the Constitutional Court, that the state act as a kind of trustee for the future generation, energy, the common heritage, and trusted screen. For me, it's really from the Anglo-Saxon heritage. It's really interesting, to be introduced this kind of word. I do not have enough time to detail it, but I think it was especially interesting. As to right to a healthy environment in Hungary, this is a really, really strict thing. As to the so-called non-derogation principle interpreted by the Hungarian Constitutional Court, because the state may not reduce the level of environmental protection guaranteed by law. Therefore, it's the only direction only to improve something. And if the Constitutional Court think that there is a reduction, in this case, the Constitutional Court repeals the law. I think it's really, really strict thing. And another interesting issue connected to the so-called precaution principle. This is the precaution principle of the Constitutional Court. Therefore, it's not the same as the precautionary principle in other laws. But this is a constitutional precautionary principle, really interesting, because, for example, one aspect of this principle that the state shall prove that it was not a reduction. Prove as a court, in fact. It's a really, really interesting aspect. And what is the change after that? In this way, first of all, the role of the Constitutional Court, we can see that the Hungarian Constitutional Court reinforced the fact-finding nature of the Constitutional Court in environmental cases. The methods of interpretation and reasoning used by the Constitutional Court are strange and arbitrary in several places. Therefore, maybe the achievements is beautiful from an environmental perspective, but how they did it, for me, for my critics, I can imagine that our justices from Constitutional Court, they are going to kill me because of my opinion, but sometimes they refer to given, for example, books, Oxford published books. Maybe my problem that they didn't refer to my book. That may, and after that, I could accept it. But when the basis of reasoning given books, it's interesting. What is the sources of law, and the methodology. Therefore, this part is really interesting in a given sense. But as to the substance of the decision, first of all, the climate is also an environmental component. Or, for example, the right to a healthy environment. It's really interesting. I previously mentioned the non-derogation principle, that if there is an existing rule and the state would like to introduce a new law considering this topic, the state cannot reduce the previous level of protection. But this decision is about the situation that there is a rule, there is no amendment of the law, but Constitutional Court say that now this level is not enough, and I repeal, because there are changes in the environment. Therefore, an existing level is not enough now, and that is the new moment, I think, of this. And another interesting situation, it's also connected to the, in my opinion, in a given sense, to the non-derogation principle that we have already at a given level, that taking into account how can we prove it. Therefore, the Constitutional Court determined an obligation for the state to prepare a proper national asset register via which we can assess the situation, whether what is the level now and what is the demand in connection with this. I think it's also really, really interesting aspects, but I think I had only this time. And thank you for your kind attention.
So, ladies and gentlemen, I have a pleasure to present my contribution, or just few ideas from my contribution regarding the constitutional proposals. And I would say since 2022, when the book was prepared, there were no major changes in the Slovak regulation of in the constitutional regulation of the environment. But I have two things which I would like to point out. The first one, which was already mentioned by Professor Szilágyi, is that our constitution says in Article 44 that everybody has the right to a favorable environment. And till nowadays, even when we were speaking about the dynamic, maybe activism, maybe evolving interpretation, which is used in different areas, and especially in relation to the European Court for Human Rights, we are still at the same point in the meaning of the interpretation, who is the bearer of the right to favorable environment. Because we are not talking in our constitution about a healthy environment, we are talking about a favorable one. And according to our constitutional court, we are still acknowledging that the bearer of this right is just a natural person. It's not just it's not the legal one. And in my opinion, it's a little bit pity because the argumentation based on the idea that the only natural person, like a human, it can be met by the bad side effect or effect of the damaged environment. But I think it's not true, because behind each legal person, there are humans, and they're interacting in their operation of this legal entity in everyday life, and they can meet the bad effect or of the damaged environment. So that's the one thing I would like to suggest, that it can be, because in doctrine we are still thinking also about the legal person like a bearer of this right, but the Constitutional Court is still opposing these ideas. So maybe it would be nice. It doesn't need to be made in the form of the change of the Constitution. It's sufficient if there's only a change of the interpretation. And the other thing is that I also suggested that we can make a little bit more clear what is meant by the broad concept which was established in our constitution, because we still have the idea in the constitution that we have a favorable environment to proper use of the natural sources. We have a special protection of water, which we are quite famous for in Slovakia. And I think at the end it is a good idea, because we made something which is like our natural source. You can have it like a natural heritage, I think. And we made a special protection of it. And it's always good, because on one side, we can include it in a very general scope, but of the concept of the natural resources. But on the other side, here is something which is really precisely stated. This is the protection of what we want to do with our water, how we want to transport it, how we want to use it. And so the other thing is, what is the healthy environment? What is the favorable environment? Such a broad concept. Okay, we would like to set some kind of standards, and it cannot be just simply done by the Constitutional Court or by the legislator, because it's very specific and it's very difficult to determine what we can include in the such a broad concept. So maybe this suggestion or this proposal is very theoretical, but I don't want to let it to stay in the role of just of illusionary right, like it's stated in our constitution. So we need to fulfill it with some kind of concept or some kind of content. But I understand it's very difficult because, for example, you mentioned there, well, no good practices mentioned with in relation to liability, environmental liability. So yes, that's true, because it's also linking this idea that is very broad. And it's, for example, in Slovakia, when you want to reach the decision of the court where there is acknowledgement of the breach of your right to favorable environment, and it's rare cases, and it's not in this proper way done, because it's usually only when it's in interaction with other rights guaranteed by the Constitution. So that's a very difficult issue, and we also understand that, for example, to setting some kind of standards which can be regarded at the constitutional level by the Constitutional Court to create some content of this constitutional right is difficult, also in a way that for everybody can be the standard a little bit different. And it can be also done in each type of natural resource. So yes, I think there is a lot of work to do, but in my opinion, it should be done only in the way of the interpretation of the constitutional concept. I find it sufficient for nowadays. I'm sorry that I couldn't bring up here some perfect constitutional court decision or something like that, big changes, but I hope there will be some in the future, of course, only in relation to positive regulation of these rights for the people. So thank you very much.
Thank you very much, dear organizers. Thank you for having me here. It's a pleasure and honor, first of all. Honor. Thank you so much. The developments after our study from 2021, I think that they are limited. I would conclude something with such a description, but two key developments I would like to point out. I think that we should stress that we have a new actor in the field of debate over environmental rights in Poland. I mean, the Commissioner for Children's Rights. I'm referring to the year 2025, when she formally called on the Polish government through the ministers of foreign affairs and climate to support drafting of a new additional protocol to the European Convention on Human Rights, which would guarantee, of course, the right to a clean, healthy and sustainable development. This is the first one. Maybe I will describe also the answer. The government responses have been cautious, of course. The negotiations in the Council of Europe are ongoing. It's hard to reach an agreement. And a binding instrument could lead to more Strasbourg court cases against Poland. Anyway, taken together with the earlier actions of the General Ombudsman, especially the intervention in the Rybnik cleaner case, these developments convinced me that it is worth seriously considering the establishment of a dedicated environmental and future generations commission. So this is the main argument, a little bit change of delegate proposals, who could consolidate and strengthen these initiatives taken by the General Ombudsman and Children's Rights Ombudsman, let's say something like that. The second development, it's connected with the right to a healthy environment from Article 68, para 4. So it is also connected with this de lege ferenda proposal, maybe a good practice. I mean, the progress of the Constitutional Tribunal case law remains limited, but I found one exception. I mean, the judgment K27/23, where the tribunal relied on Articles 68, para 4. I mean, one of the environmental provisions from the Constitution. Although the case concerned epidemic illnesses, Article 68, para 4 also covers the prevention of negative health consequences of an environmental degradation. So tribunal in this case underlined that the Council of Ministers bears special responsibility for fulfilling the duty arising from this provision. And the second one, Article 68, para 4, forms part of the constitutional right to health. Unfortunately, the judgment didn't go further. I mean, in my opinion, this was a missed opportunity to clarify that Article 68, para 4, read together with para 1 of the same article, could provide the basis for an individual right to protection from health impacts of environmental degradation. So I guess that's my time. Thank you so much.
Thank you. Good morning, everyone. Thank you for this opportunity to present and follow up on your wonderful research that you published in the book. The reason why the presentation didn't include the information on the Czech Republic was that I didn't send the update from the 2022, but the book that was highlighted includes the chapter on the Czech Republic. So I'm building up on a solid foundation that was presented. It was not written by me. I have to say that I'm an environmental law expert, but I do combine expertise in environmental law and in constitutional law. And in order to follow up on what was said by my colleagues about the constitutional law, de lege ferenda, suggestions, proposals, recommendations, I'd like to say that the Czech Republic is lucky to have made a progress in the things that you were highlighting. The standing for the when it comes to the right to healthy environment, Czech Republic is no longer limited to only natural persons. We have a solid case law of the Constitutional Court now saying that also non-governmental organizations do have a standing, because it doesn't make sense. It's logic when people get together and form an association in order to represent their interests, to have also the standing in front of the court, to make it procedurally easier to only deal with one subject, with one entity. So we're further on that way. When it comes to I totally agree with you when you mentioned. I think all of you mentioned that the right to healthy environment or right to favorable environment, as it is mentioned in the Czech Constitution, the content of the right needs to be defined. Because when it comes down to a daily life, what does it mean that I or everyone has the right to healthy or favorable environment? What does it mean in practical life? And I have to say that I'm very optimistic in that sense. And I'm building up on the keynote that we heard this morning, that your work, our work is appreciated, also the work of academics. What we achieved was that in 2016, we published an article that was the first proposal and suggestion, how do you define the right to healthy environment? And it was just the first bird in the early spring to be published. And I have to say that the Constitutional Court accepted the suggestions that we had and built up on that. And I also like to mention that these ideas that we had build up on things that are in environmental law for 40 years already, since 1972, when the first UN Global Conference was held in Stockholm. And I also have to say that in connection to the children's rights that you mentioned, that I don't know if you have noticed that there's general comment number 26 to the United Nations Conventions on the Rights of the Children, which says that the convention, despite the fact it doesn't say, it doesn't have the right to healthy environment of children included explicitly in the convention. It comes out of the convention implicitly. And so I think that that it's a very good path forward with the activities and initiatives involving and building up on children's rights. The Czech Republic has some evolution in that sense as well. And that is, besides the General Public Defender of Rights, we established also the Children's Rights Public Defender. Yet the position has not yet been fulfilled by the right person. We're still waiting who's gonna be the one. But I think that's a path. Another path that I would like to suggest is came out from the Polish presentation, and that's when we think about protecting future generations, which is the main or one of the main topics, we need to think about protecting our health, because our bodies, our reproductive health, produce the future generations. So I'm very much into really interpreting not only the right to favorable living environment, but also along with it, interpreting the content of the right to health. What does it actually mean? I have a short suggestion that I'd like to display. It's going to be written in my article, which will be presented to you. Sometimes we can also find inspiration in nature. And this rock is presented by my university in front of the Faculty of Nature or of Science. And it's a pudding stone, a stone made out of these round stones connected by some glue back in the history, right? And right to healthy environment is a composite right. It does. I know it seems vague. What does it? What is it actually? But if you think about what's the definition of the environment, well, it's made up of air, soil, nature, forests, etc., water. So if you think about that right as a composite right, divided into these elements, it has a substantive part, right to healthy water, right to clean air, connected together with the procedural glue that connects all these elements together. So I very much invite all of you who think about how to interpret the right to healthy environment, look into the nature, find inspiration. I don't think we need any changes in the law. It's all in there. If you look at the Czech constitution or the Czech environmental constitutionalism, we have all the elements in there. We have the state obligation, we have the individual right, we have the individual duty as well. And I'd like to end my presentation with the conclusion that Constitutional Court has been brave. It's in the past 10 years, it's taken up what's been written in the scholarship, and it tries to navigate the sensitive waters also around the climate change. We had just yesterday we had just the flagship climate judgment of the Constitutional Court announced yesterday. What we're going to see, we're going to need the time to analyze. But the Constitutional Court takes it up, and it also is not afraid to base its judgments on the state objective, as well as on the individual duty. I can see when you read the judgments of the Constitutional Court, you see very much the difference. When the things are new and vague and abstract, it's kind of hard for the court. But it tries to find a way around building up also on the European Court of Human Rights case law, mainly on the right to private life, which helps a lot. But then I think the future is bright, and I'm very much optimistic. We don't need any changes in the Constitution. It's all written there. Thank you very much.